Welcome to Casa Academy Chapter 7, Part 1, where we will cover federal and state laws pertaining to real estate. As you progress through your real estate education, you're going to quickly realize that navigating the legal landscape is about so much more than just knowing how to write up a contract. I like to think of your real estate license as a high-performance engine. Florida's license laws, well, they're the steering wheel. But the federal and state laws we're exploring today, they are the guardrails keeping you from crashing. Together, they establish the absolute crucial legal boundaries of a successful professional real estate career. You'll encounter these guidelines in almost every single transaction you handle, from that very first phone call straight to the closing table. Okay, let's dive into this. Today, we're looking at 1. Fair housing foundations. 2. Illegal discriminatory practices. 3. Stigmatized properties in Florida. 4. The Landlord and Tenant Act. And 5. Telephone solicitation laws. We're going on a macro to micro journey here, from broad federal constitutional rights all the way down to your everyday business practices. Starting us off, Section 1, Fair Housing Foundations. Ensuring equal access to housing opportunities is one of the most absolutely critical topics in this entire chapter. Our nation's fair housing laws have evolved significantly over time to protect more and more people, and getting a handle on this timeline is absolutely essential for you. It all starts way back with the Civil Rights Act of 1866. Just think about the year for a second. 1866, right after the Civil War. That historical context is exactly why the specific act holds zero exceptions for racial discrimination. It was one of the very first federal laws designed to protect civil rights and property ownership, and that standard remains absolute today. For your exams, you absolutely must remember that the 1866 Act protects only based on race, and it literally has no exemptions whatsoever. None. Zero. Then we jump forward a century to the Civil Rights Act of 1968, which you'll commonly hear called the Fair Housing Act. This expanded federal protections tremendously. It prohibited discrimination based on color, religion, sex, and national origin, in addition to race. And later on, modern amendments expanded those protections even further, bringing in disability, which is sometimes called handicap status in older texts, and familial status, which generally just refers to families with children. To put this into a modern context, the U.S. Department of Housing and Urban Development, or HUD, regularly tracks and investigates housing discrimination complaints. And the data tells a really clear story. A ton of today's most frequent complaints involve allegations related to disability and familial status. So what does this actually look like in the real world? Imagine a landlord refusing to let a tenant install a necessary wheelchair ramp. Or maybe a property manager trying to restrict a family with toddlers to a first-floor unit just because they assume children will be too noisy upstairs. These aren't just minor technicalities. They are the most frequent, actively prosecuted violations HUD investigates today. As a real estate professional, you've got to be exceptionally careful to ensure you're providing fair, equal, and consistent service to these specific protected classes. Understanding your responsibilities here is exactly how you avoid devastating fair housing violations and protect your career. Now, moving right along to Section 2, Illegal Discriminatory Practices. What's really interesting about this next section is that these are specific violations that frequently appear on licensing exams. The Fair Housing Act specifically targets a few notorious discriminatory practices that you're highly likely to see. First up, we have blockbusting. Imagine a neighborhood where someone starts slipping flyers under doors or knocking on porches, whispering that property values are about to plummet because a certain demographic is moving in. They actively create a panic, they buy the homes from terrified owners for pennies on the dollar, and then they flip them for a massive profit. How do they pull it off? By manipulating fear based on a protected class entering the area. That's blockbusting. It's a predatory, manipulative, fear-based tactic designed to generate fast turnover and cheap listings, and it is strictly illegal. Remember, your job is to stabilize communities, not exploit them. The second practice is steering, which is sometimes referred to as channeling. This happens when a real estate professional directs individuals toward or away from certain neighborhoods based on a protected characteristic, rather than the buyer's actual housing preferences or financial qualifications. What's particularly insidious about steering is that, well, sometimes it isn't overtly malicious. Sometimes an agent actually thinks they're helping a buyer by assuming they want to live near a specific place of worship or cultural center based on their background. But the law is crystal clear here. You cannot limit a buyer's choices based on your own assumptions about their protected class. Showing a buyer homes only in specific, segregated areas simply based on their religion or national origin is a subtle but highly damaging form of discrimination. And yes, it can absolutely cost you your license. The third specific practice is redlining. Now, unlike blockbusting and steering, which are typically committed by real estate sales associates, redlining is almost always a lender violation. Redlining occurs when banks or lenders refuse to make loans or when they impose entirely different lending standards based purely on the location of a property. Historically, lenders would literally draw a red line on a map around certain neighborhoods and refuse to issue mortgages there, effectively starving entire communities of financial growth. They did this often because of the demographics of the people living in that specific geographic area. Recognizing the difference between these three practices, blockbusting, steering, and redlining, is going to be crucial for your exam. So, the crucial point to take away is this. While there are a few very narrow exemptions to portions of the Fair Housing Act of 1968 in highly specific rare scenarios, there are never any exemptions that permit discrimination based on race under the Civil Rights Act of 1866. It just doesn't matter if it's a commercial property, a residential lease, or a private owner selling their own home. There is never a valid excuse. Period. Let's transition into Section 3, Stigmatized Properties in Florida. And by the way, your verification code is 987411. Now, let's shift our focus to state-specific issues and properties with negative reputations. In real estate, you're inevitably going to encounter what's known as a stigmatized property. This is a property with a negative reputation due to events that have absolutely nothing to do with its physical condition. You might find yourself listing a property with a dark history, maybe a widely publicized crime, a murder or suicide, or even a local legend that the house is haunted. Now, in some states, dealing with these psychological stigmas is a total nightmare for an agent. But in Florida, the law draws a hard, bright line between the physical condition of the roof and the psychological reputation of the home. Florida law is very clear here. These circumstances are generally not considered material facts. Because of that, a real estate licensee is not legally required to disclose them to a potential buyer. You don't have to play ghost hunter or true crime detective. This rule also applies to medical histories, specifically regarding HIV and AIDS. Sometimes questions arise about whether a property is stigmatized because a former occupant had HIV or AIDS. Well, because HIV and AIDS are federally protected disabilities, treating them as a stigma would be a severe fair housing violation. This information is absolutely not considered a material fact that must be disclosed. In fact, Florida law doesn't just say you shouldn't disclose it, it actually protects you from being sued for keeping that private medical information confidential. The courts and the legislature actively shield licensees from liability for failing to disclose these types of stigmatizing events, which ensures you can respect privacy without fearing a lawsuit. Let's move to Section 4, the Landlord and Tenant Act. Let's see how this builds as we drill down from state property quirks to the daily mechanics of residential leasing under Chapter 83 of the Florida statutes. Chapter 83 of the Florida statutes is known as the Landlord and Tenant Act, and let me tell you, it is your operational Bible if you touch residential leasing or property management. It covers everything. We're talking landlord responsibilities and tenant rights, strict security deposit requirements, the rules for when a landlord can actually access the rental property, lease termination procedures, and prohibited practices. Let's make this practical, right? If you're managing a duplex, let's say property management file number 458771, every single decision you make is governed by this chapter. It dictates exactly how many hours of notice you need to give before knocking on a tenant's door for a repair. It sets out the precise, unforgiving timelines for returning a security deposit or making a claim on it after a tenant moves out. You simply cannot operate on assumptions. You must strictly comply with the requirements of Chapter 83 every single day. All right, transitioning to our final section, Section 5, Telephone Solicitation Laws. Let's look at how everyday lead generation and prospecting must comply with strict regulations. Picking up the phone is a classic hustle, right? It's a very common and effective way for new licensees to generate leads and build their business. However, prospecting is heavily regulated. Consumers have significant, robust protections against unwanted solicitation calls under both federal and state telemarketing regulations. Violating these solicitation laws isn't just a slap on the wrist or a minor oops, it is a massive federal violation. We're talking about fines that can exceed $40,000 per single illegal phone call. Just let that sink in for a second. Calling someone on the Do Not Call registry can literally bankrupt your new business before it even gets off the ground. Ignorance is not a defense here, so you must understand the rules and rigorously scrub your lead lists before you start dialing. We've covered a really wide variety of legal concepts today. From navigating local haunted house rumors in Florida to abiding by the rigid federal lines of the 1866 Civil Rights Act, the common denominator is treating the public fairly and lawfully. Federal and state laws are expressly designed to ensure equal housing opportunities and protect consumers. The laws we've covered aren't just exam hurdles you need to memorize and forget, they are the blueprint for consumer trust. If there is one central guiding theme you take away from this entire chapter, it is this: discrimination has absolutely no place in real estate. As a professional, you are legally bound to provide fair, consistent, and lawful service to everyone, regardless of their protected characteristics. As you prepare for your exam and step into your future career, I want to leave you with a bit of a challenge. It's easy to memorize the laws, but applying them day in and day out, that's what makes you a true professional. Will your daily real estate practice reflect a commitment to fair, equal, and strictly lawful service for all consumers? Keep that standard in mind with every single transaction you handle.